20 years after the 9/11 terror attacks on America, which killed nearly 3,000 people, the man who's thought to have masterminded them, Khalid Sheikh Muhammed, and his 4 key associates are in court for pre-trial hearings. It's their 42nd appearance, and the judge is the 8th to have presided over the case, which has been bogged down for years. The proceedings are taking place in Guantanamo Bay in Cuba, from where our North America correspondent Alim Makboul sent this report.
A demand for justice following that horrific day 20 years ago led to a wide-reaching response, but one that since led to accusations the US perpetrated injustice. In a tiny corner of Cuba, one notorious byproduct of the 9/11 attacks still remains. Prisoners are still being held in limbo in Guantanamo Bay. Well, of course, the US authorities have allowed us to be here, but they are extremely restrictive in controlling what we can show in terms of people and structures. They certainly haven't allowed us anywhere near the detention facilities where the remaining prisoners are being held. When I was last here, things were very different. We saw some detainees mingle and eat together and interact with the guards, though we knew of other camps where prisoners didn't have such privileges. We were even able to wander through the long-abandoned Camp X-Ray, where in the months after the 9/11 attacks, men and boys were first transferred, interrogated, and in many cases tortured. Of nearly 800 men and boys who've been detained at Guantanamo Bay, 39 remain. About a quarter were cleared for release as far back as 2010, but are still waiting to leave. 2 have been charged and convicted in what are called military commissions. 17 have never been charged, but will remain in prison for life because they're deemed a security threat. The other 10 are still awaiting trial. They include 5 men accused of involvement in the 9/11 attacks. Well, for the first time in more than 18 months, those 5 men were inside a courtroom. We couldn't film it, but we were in the gallery just through the glass, just feet away from those defendants, including at the very front there with the ginger beard, Khalid Sheikh Mohammed, the man who it's believed conceived of the idea of 9/11 and took that idea to Osama bin Laden. But the proceedings themselves were extremely slow.
People often ask, is there an end in sight? And for a long, long time, there was not even a middle in sight. But now, we are in the middle of the case because wrestling with the question of what effect torture has on the admissibility of statements is really the heart of the case.
Detail. Oh.
But that's where things are stuck. All the while, the family members of those killed in 9/11 wait for resolution, and the detention centre here looks no closer to shutting down. And every time there are these pre-trial hearings involving the 9/11 suspects, family members of victims of the attacks are invited to come and observe proceedings, and indeed some have been here this week. They've often talked about how difficult it is to sit so close to men accused of involvement in killing their loved ones. They've talked about their frustration about how after all this time they still don't even have a trial date for those men, and of course it's all the more difficult this visit because they'll be commemorating the 20th anniversary of the tragedy in just a couple of days' time, a long way from home and in a place with such a dark and uncomfortable history.
Alim Makboul, thank you.
The latest court proceedings involving the 9/11 Guantanamo Bay trial of Khalid Sheikh Mohammed, Ammar al-Baluchi, Ramzi bin al-Shibh, Mustafa al Hawsawi, and Walid bin Attash, in which Baluchi's lawyer, Connell, has brought evidence that the Federal Bureau of Investigation were directly involved with the interrogation process, the Central Intelligence Agency program, the Rendition, Detention, and Interrogation, RDI. In 2019, one of the FBI agents involved, FBI Special Agent Adam Drucker, involved in the clean team in interviews, revealed he had collaborated extensively with the CIA in the RDI torture program, sending CIA black site operatives hundreds of questions to ask the detainees. Guantanamo Bay detainee lawyers such as Connell, Alka Pradhan, Rita Radostitz, counsel for Khalid Sheikh Mohammed, Walter Ruiz, and counsel for Mustafa al Hawsawi are now asking for more evidence regarding just how much more involved the FBI was in the RDI program itself, while also pushing for a definitive trial date. Back in 2014, former CIA Director George Tenet, Porter Goss, and former NSA Director Michael Hayden wrote a joint Wall Street Journal op-ed claiming the interrogation program led to the capture of senior al-Qaeda operatives, disrupted terrorist plots, and formed an essential part of the foundation from which the CIA and the U.S. military mounted the bin Laden operation. Connell also argued that his client had not committed a war crime and added, "The government says their position for their entire case for guilt is based on the idea that Osama bin Laden had the power of the president of a country or the legislature of a country to declare war in 1996. Pradhan, another lawyer for Baluchi, also said that to hear senior members of the military argue that an alleged terrorist can declare war against the United States of America is jarring because it contravenes all existing laws. She said she felt absolute all-consuming rage about the overall process and called it a clear farce proceeding. Back in September 23rd of 2019, Special Agent Stephen McLean of the FBI testified about his involvement in the high-value detainee prosecution task force and the January 2007 clean team questioning of al-Baluchi. McLean stated that before his interrogation, he had no prior knowledge of al-Baluchi or his statements to the CIA while detained in a secret CIA prison. James Connell, civilian death penalty attorney for al-Baluchi, asked about statements McLean had previously made to him regarding the CIA's role in selecting him for the HVD task force. McLean promptly denied knowing of any CIA involvement in his selection for the task force. However, in a revealing article concerning FBI involvement in the RDI program by Margot Williams of The Intercept in 2019, the prosecution sent out a 25-page classification guidance revealing a number of new facts that had previously been classified, but also invoking national security restrictions to censor words that had been spoken in prior open closed sessions. The most startling revelation from this classified document, described in open court by James Connell, is that FBI agents were detailed to the CIA's Rendition, Detention, and Interrogation program, a fact that the Senate Intelligence Committee that investigated the programs and produced the 2014 torture report apparently did not know about. By contrast, the torture report said that then FBI Director Mueller began seeking direct FBI access to Khalid Sheikh Mohammed in order to better understand CIA reporting indicating threats to U.S. cities. Then CIA Director George Tenet made personal commitments to Director Mueller that access would be forthcoming, the report noted. But the CIA's Counterterrorism Center successfully formulated a CIA position whereby the FBI would not be provided access to Mohammed until his anticipated transfer to Guantanamo Bay, Cuba, which did not happen until September of 2006. But according to Connell, the FBI did have access to Mohammed and other black site detainees between 2003 and 2006, when then President George W. Bush acknowledged the CIA's secret prisons and brought 14 detainees to Guantanamo to face military tribunals. During that period, Connell said the FBI sent well over 1,000 questions to the CIA for the agency to ask detainees, including Mohammed, who was subjected to waterboarding 183 times. By January of 2020, James Connell called James Mitchell, to testify in support of his team's motions to suppress incriminating statements by al-Baluchi at Guantanamo Bay in 2007, about 4 months after he arrived from the abusive black sites. James Mitchell spent much of his testimony defending his actions as legal and argued that he helped stop future attacks. The 5 defense teams claimed that past torture at the CIA-run black sites taints any statements their clients later made to the FBI investigators at Guantanamo Bay. And thus, everything must be excluded from the trial. James Mitchell and Bruce Jetson's copted the Survival, Evasion, Resistance, and Escape SEER program, in which the CIA were personally operating the enhanced interrogation techniques to become the primary factor in forcibly extracting information they believe were behind and being withheld from detainees at CIA black sites in countries where human rights violation laws do not apply to enemy combatants. In 2005, Mitchell and Bruce Jessens formed a company called Mitchell, Jessen and Associates, with offices in Spokane and Virginia, and 5 additional associates, 4 of them from military SEER programs. And by 2007, the company employed around 60 people, including former CIA interrogator Deuce Martinez, Karen Gardner, and a former senior training official at the FBI Academy, Roger Aldrich, a legendary military survival trainer. White House legal counsel attorneys John Yoo and Jay Bybee advised the Central Intelligence Agency, the United States Department of Defense, and the President on the use of enhanced interrogation techniques. Mental and physical torment, coercion, such as prolonged sleep deprivation, binding in stress position, and waterboarding, and stated that such acts, widely regarded as torture, might be legally permissible under an expansive interpretation of presidential authority during the War on Terror. Meanwhile, military lawyer for another of the defendants of Walid bin Attash had asked Judge Air Force Colonel Matthew McCall to order the government to produce the names of FBI witnesses who were at CIA black sites in the 30-day periods before and after bin Attash's presence at the sites. Air Force Major Jay Peer said his team initially asked for the names of agents who were co-located at the sites with bin Attash, then broadened its temporary request, and the prosecutor said that no agents were at the sites at the same time as their client. Pierce said the government's refusal to provide the names speaks volumes, that his team is entitled to investigate how FBI agents helped prepare CIA interrogators for interviews, review the intelligence learned, and later plan for future sessions. Echoing his colleagues from days prior, Pierre noted that the defense teams did not begin to receive any discovery on the FBI's role at CIA black sites until mid-2018. But what does that tell you? It tells you that the government, along with the CIA and State Department, are unwilling to cooperate with defense lawyers and with the defendants who are accused of the egregious crimes of September 11, 2001. It's now 20 years. The trial hasn't started. It seems to me that they don't want it to start. They want these people to drop dead at Guantanamo Bay prison. That's because whether they had the evidence or lack thereof, all of it was made under the duress of torture, which is not legally permissible in any court, even in a military tribunal. So it's either they have the evidence to convict or they don't have any evidence at all.